In today's lecture, we'll be covering the topic of municipalities, that is starting from Article 243p. So in 243p, the definitions of some words are given, that is committee. Committee means a committee constituted under Article 243s. District means normal district in a state. Metropolitan area means an area having a population of 10 lakhs or more, comprised in one or more districts and consisting of two or more municipalities or panchayats or other contiguous areas specified by governor by public notification to be a metropolitan area for the purpose of this part. So all these things covers a metropolitan area and it is specified by governor. Fine. Next is municipal area. Municipal area means a territorial area of a municipality. It is notified by, again, governor. Fine. So these are the definitions of the words which will be used in the further articles. So municipality means an institution of self-government constituted under Article 243Q. We'll be going through 243Q, that is the constitution of municipalities here. Panchayat means a panchayat constituted under 243B. This we have already covered, panchayat, because first of all we need to know what is panchayat, then only we come to know about municipalities. Population means the population as ascertained at the last preceding census of which the relevant figures have been published. Fine. Now coming to constitution of municipalities, 243Q. So there shall be, so it is, shall means it is mandatory. Fine. So there shall be constituted in every state. So it is mandatory. All these things should be constituted in every state. That is a Nagar Panchayat by whatever name called for a transitional area. So Nagar Panchayat is for a transitional area. That is an area in transition from a rural to an urban. It is in transition phase. So we call it Nagar Panchayat. Then municipal council for smaller urban area, municipal corporation for larger urban area. Okay, in accordance with the provisions of this part, provided that a municipality under this clause may not be constituted in such urban area or part thereof as the governor may by public notification specify to be an industrial township. So the clause says that the governor, if he wants, he can specify it to be an industrial township with regard to the size of the area and the municipal services being provided or proposed to be provided by an industrial establishment in that area and such other factors as he deems fit. Yeah, so their municipality may not be constituted. It depends on the governor. Fine. So this is you can say from this part, this is an exception. This is an exception. That is the industrial township. Next. Now here another clause is also there. Clause number 2. It says a transitional area. It says a transitional area, a smaller urban area or a larger urban area means such area as the governor may, having regard to the population of the area, density of the population, the revenue generated for local administration, the percentage of employment in non-agricultural activities, the economic importance, or such other factors as he deems fit, specify by public notification for the purpose of this part. So in this part, we learn about transitional area. We also learn about the smaller urban area. We also read about the larger urban area. Now these are those areas. Now there are some parameters. You need to remember the parameters and they are mentioned in the constitution itself. Governor with regard to number 1, population, number 2, density, number 3, revenue generated for local administration. Okay, for local administration. Number 4, percentage of employment in non-agricultural areas. So we are not talking about the agricultural activities. So percentage of employment and then economic importance. Okay, number 5. And any other factors we can take into account. The governor can take into account to specify by public notification which is a transitional area, which is a small urban area, which is a large urban area. So this article becomes very important from prelims point of view because these are the parameters. They will ask the parameters. Okay. Now coming to the composition of municipalities. So when you talk about the composition, it's mostly same like the panchayat. Here, the state government will play a very big part. The state legislature. So here, as provided in clause 2 is the state legislature will provide the representation, like who will be the members and who will be the part of that municipalities. So as provided in clause 2, all seats in municipalities shall be filled by persons chosen by direct elections from the territorial constituencies in the municipal area, and for this purpose each municipal area has been divided into territorial constituency to be known as wards. Ward elections happens, right? So that is nothing but municipal elections. So here the state legislature may by law provide for the representation of the municipality of persons having special knowledge or experience in municipal administration. So here the state legislature will make a law. In the law they will provide the specifications where persons there can be persons having special knowledge on municipal administration, members of the House of the People, okay, and members of the Legislative Assembly of the state representing constituencies which comprise wholly or partly the municipal area. So House of the People here is Lok Sabha. They can also come to represent the constituencies wholly or partly of that municipal area, even the members of assembly. Now members of Council of States and members of Legislative Council of the state, registered electors within that municipal area, they can also come. Fine. But it all depends upon the law made by the legislature of the state. Fine. Next. Now also the chairperson of the committee is constituted under clause 5 of article 243s. This is a separate article. This is the next article. We'll come to know about that. So these provisions are to be made by the state legislature through a law, provided that the persons referred to in paragraph 1 shall not have the right to vote in meetings of the municipalities. Now this becomes very important. Now who will be the persons who will not have the right to vote in the meetings of panchayats? That is paragraph 1 means these persons, if selected, these persons having special knowledge will not have the right to vote. Rest everyone will have right to vote in municipal meetings. Remember, it's a constitutional provision. Fine. Next. And the manner of election of chairperson also will be done by state legislature. The state legislature will provide the manner of election of the chairperson of the municipality. How the chairperson will be elected, it all depends on the state legislature. So the manner has been given to the state legislature. So there is no clear-cut specifications in the constitution. The constitution has given the power to the state legislature by how, like what will be the manner of elections of the chairperson of municipality. Next, 243s. Now the constitution and composition of ward committees. Okay, ward committees. Now first clause, there shall be constituted, it's mandatory, shall be constituted ward committees consisting of one or more wards within the territorial area of municipality having a population of 3 lakhs or more. So here there is a specification. Any territorial area of a municipality, if it has a 3 lakhs or more population, then there shall be constituted ward committees consisting of one or more wards. Now, who will make the provision? Again, the state legislature will make the provision respect to the composition and territorial area of ward committees, the manner in which seats in the ward committees shall be filled. That will also, the manner will also be given by the state legislature. Third clause, a member of the municipality representing a ward within the territorial area of the ward committee shall be a member of that committee. So a member of the municipality who represents a ward within the territorial area of the ward committee shall be a member. Now where a ward committee consists of one ward, the member representing that ward in the municipality shall be the chairperson. If a ward committee consists of one ward, then the member representing that ward in the municipality shall be the chairperson. Now if 2 or more wards are there, if a wards committee consists of 2 or more wards, then one of the members representing such wards in the municipality elected by the members of the ward committee shall be the shall be the chairperson of that committee. Okay, so here elected by the members of the ward committee, because 2 or more wards are there, right? Fine. Now, the last clause, fifth, is nothing in this article shall be deemed to prevent the legislature of a state from making any provision for the constitution of committees in addition to the wards committee. It means now ward committees composition and constitution is mentioned in the article 243s, and also the power has been given to state legislature. Okay. But apart from this, any other committees apart from the ward committees, if it has to be made, yes, it can be made. There is a provision in constitution, but who can make it? It is again the legislature of the state. Okay, now coming to reservation of seats. Reservation of seats is also important because here SC and ST and women thing will come. Mostly it is similar with panchayats, but still then we need to know reservation of seats. First of all, seats shall be reserved for scheduled castes and scheduled tribes in every municipality, and the number of seats so reserved shall be as nearly as possible. So here the thing is as nearly as possible. So clear cut it is not there. Like jitna ho sake utna, as nearly as possible, the same proportion to the total number of seats to be filled by direct elections in that municipality as the population of scheduled caste in the municipal area or of the scheduled tribes in the municipal area bears to the total population in that area, and such seats may be allotted to the rotation to different constituencies in the municipality. So basically the clause 1 says is seats has to be reserved for SC and ST, and direct election will be there, and it depends on the population, proportion to the population, which is a very natural thing. Now coming to specifications, not less than 1/3 of the total member of the seat shall reserved under this clause shall be reserved for women belonging to SC and ST. So minimum 1/3, not less than that. 1/3 for women belonging to SC and ST. Now not less than 1/3, including the number of seats reserved for women belonging to SC and ST, the total seats have to be filled by, again, direct elections. Here clause number 2 says, okay, 1/3 should be given to them. Now the same 1/3 should be given by, it should be done by, filled by direct elections in every municipality shall be reserved for women, and such seats shall be allotted by rotation or different constituencies in the municipality. Fourth, the offices of chairpersons of municipality shall be reserved again for scheduled caste, scheduled tribes and women, but here the power has been given to state legislature. So when it comes to offices of chairpersons of municipality, yes, reservation is there, but the authority lies with the state legislature. The manner how they will do, the state legislature has to do it by law. Okay, regarding the offices of chairpersons. Okay, next. The reservation of seats under clause 1 and clause 2, that is the SC, and women, and the reservation of chairperson of officers of chairpersons other than the reservation of women under clause 4 just now studied shall cease to have effect on the expiration of the period specified in article 334. Now 334 was in news. Now what is 334? 334 deals with reservation. Deals with reservation of seats and special representation. Okay, two like points are there in 334. One is for scheduled caste and scheduled tribes in Lok Sabha and state assemblies, and another reservation of Anglo-Indian community. Okay, same in Lok Sabha and state. Now this has been seized recently, 104th Amendment Act, and this has been again increased, like the year has been increased. So this provisions has direct connection with 334. If 334 is seized, then this provisions will cease automatically. Okay, fine. So nothing in this article, next provision, sixth, nothing in this article shall prevent the legislature of a state from making any provision for the reservation of seats in any municipality or offices of the chairpersons in the municipalities in favor of backward class. So for backward classes of citizens, the state legislature can make any provision. Okay, regarding any seats in municipalities or regarding the offices of chairpersons of the municipalities. Regarding backward class, there is no specific like 1/3 or something. It has been given, the power has been given to the state legislature. Next, now duration of municipalities. Duration of municipalities is like obviously every municipality, unless sooner dissolved under any law for the time being in force, shall continue for 5 years. Provided that the municipality shall be given a reasonable opportunity of being heard before its dissolution. If it is like there is a dissolution, so a reasonable opportunity shall be given to the municipality to be heard, and that is mandatory in nature. Reasonable opportunity, mandatory in nature, should be given. Okay, if it is getting dissolved. Second, no amendment of any law for the time being in force shall have the effect of causing dissolution of a municipality at any level which is functioning immediately before such amendment till the expiration of its duration specified. So here, same. It's the same like this panchayat. Okay. So an election to constitute municipality shall be completed before the expiry of its term, before the expiry of a period of 6 months from the date of its dissolution. If dissolution date is the municipality is getting dissolved, so before 6 months you have to hold the election. And provided that where the remainder of the period for which the dissolved municipality would have continued is less than 6 months, so there is no requirement of holding any election, because it is less than 6 months, new elections will be happening, and it is dissolving and only less than 6 months is there, so it is not necessary to hold any election. Same like panchayats. Now, a municipality constituted upon the dissolution of a municipality before the expiration of its duration shall continue only for the remainder of the period, only for the remainder for which the dissolved municipality would have continued. Like suppose a municipality is getting dissolved, so a new municipality came, it will only continue till the remainder of that period. After that, new elections will be happening. Same provision like panchayat. Okay. Next, 243, dissolution of membership. Very normal things. These are all like nothing new here. Disqualifications. If you are disqualified under any law made by the state legislatures, obviously you will be disqualified. Provided that no person shall be disqualified on the ground that he is less than 21. So minimum 21 years of age. Minimum 21 years of age. If you are less than that, you will be disqualified. And if you are disqualified under any law which is made by the state legislature for the purposes of election, then also will be disqualified if he is so disqualified or under any law made by the legislature of the state. Same thing. Normal law is there and you are disqualified, then also it will work. Okay. So disqualifications made by law and 21 years of age, number one. Next is, if any question arises so as to whether a member of a municipality has become subject to any disqualification, the question shall be referred to decision of such authority and in such manner as the legislature of the state provide. Suppose regarding disqualification, any question arises, whether it is correct or not, any question arises regarding disqualification, there the state legislature by law can provide or give that authority to any authority. Here it is not mentioned High Court or Supreme Court. Any authority depending on the legislature of a state. So it will vary from state to state. Okay. So here the power has been given to state legislature. Okay. Now next is 243W. Power, authority and responsibilities of municipalities. So here also same thing, the power has been given to the legislature of the state. The state legislature by law can endow the municipalities with such powers and authority as may be necessary, like preparation of plans for economic development, performance of functions and implementation of schemes as may be entrusted to them, including those in relation to matters listed in 12th schedule. 12 schedules deals with municipalities. Even it can endow the committees with such powers and authority as may be necessary to carry out the responsibility mentioned or regarding the matters listed in schedule. So it depends on the state legislature. Now, power to impose taxes, same thing like districts. And same thing like panchayats. Power to impose taxes and funds of municipalities. Again, the state legislature has the power. The state legislature has the power. It is not compulsory. It is may. It can authorize municipality to levy taxes, to duties, tolls, fees levied, everything, to provide for making granting nets to municipalities from the consolidate fund of the state, provide for constitution of such funds for crediting all monies received respectively by or on behalf of municipalities, and also withdrawal of such money. So it depends on the state legislature to assign or authorize or any kind of things or work you want to give to the municipality. It depends on the state legislature regarding taxes and funding. Next, Finance Commission, State Finance Commission, same thing. 243Y. So here Finance Commission already we have done for Panchayat. Same thing here, the Finance Commission constituted under Article 243I, which you have done in Panchayats, shall also review the financial position of the municipalities. So the Finance Commission, this is the State Finance Commission, it will review the financial position of Panchayats, 243I, and in 243Y it will review the financial position of the municipalities and make recommendations to the governor. So it will make recommendations. So it is mandatory for the State Finance Commission to make recommendations to the governor regarding all these things, regarding the distribution between the state and municipalities and the net proceeds of the taxes. Taxes से जो revenues आता है उसका जो proceeds से कैसे distribute होगा, the duties, the tolls, the fees leviable by the state, which may be divided between them under this part, and the allocation between the municipalities at all levels of the respective shares of such provides, how it will be divided between the state and municipalities, everything, the recommendations will be given by the State Finance Commission. The determination of taxes, duties, tolls, fees, which may be assigned to or appropriated by the municipalities, the granting aids to municipalities from the consolidated fund of the state, everything will be recommended by the State Finance Commission. The measures needed to improve the financial position of the municipalities, any measure if it is needed to improve the financial position, it will be recommended by the Finance Commission or the State Finance Commission, and any other matter referred to the Finance Commission by the governor in interest of sound finance of the municipalities. Apart from these, any other matter, if it is required to with the interest of sound finance of the municipalities, it has to be given by the governor. Obviously, it is not a discretionary power. Okay, it is not a discretionary power. Obviously, it will be done by the aid and advice of the government, CM and Council of Ministers. But yes, finally, it will be done by the governor. The governor shall cause every recommendation made by the commission, that is the State Finance Commission, under this article, together with an explanatory memorandum, so as to the action taken thereon to be laid before the state legislature. The governor will take all these recommendations with an explanatory memorandum and will put it in the state legislature. Next, audit account, same thing. From municipalities, panchayats, everything is done by the state legislature. The state legislature may make provisions with respect to the maintenance of accounts. It does not mean the state legislature will do it. State legislature will make provisions with respect to the maintenance of accounts, audit of accounts of municipalities. Depends on the state. Then elections to the panchayats, elections to the municipalities. So election, the superintendent's direction and control and preparation of electoral rolls, conduct of all elections, municipalities shall be vested with State Election Commission. And subject to the provisions of this constitution, the legislature of a state may by law make provisions with respect to all matters relating to or in connection with election to the municipalities. Subject to the provisions, legislature of a state can also make any provision which is connected to the elections of municipalities. It can do. Okay. Now application to union territories, this will work for union territories also. All these things are mentioned. The provisions of this part shall apply to all union territories, and union territories we have already covered. Provided that the President may by public notification direct that the provisions of this part shall apply to any union territory or part thereof, subject to such exceptions and modifications as he may specify in the notification. It means President will direct all these provisions of these municipalities will be applied to the union territories. But yes, if President wants, he may specify some exceptions and modifications also. Part not to apply to certain areas. Obviously, this part will not apply to the scheduled areas, because we have different article for that. 244 article we have for tribal areas. Nothing this part shall be construed to affect the functions and powers of the Darjeeling Gorkha Hill Council. Okay, so all these things, same thing. It's the same as panchayat. Okay, it will not be implemented in scheduled areas and tribal areas. Next, committee for district planning. So there shall be a committee. So it's mandatory. There shall be a committee. Like there shall be a district planning committee at the district level in every state to consolidate the plans prepared by panchayats and municipalities. So the plans which are prepared by panchayats and municipalities for developmental plan, so they will consolidate it. So now in district planning committee, the composition, who will be there, how it will be done. So all these things are done by state legislature. Will make provisions with respect to composition and the manner in which the seats in such committees are filled. All will be given by state legislature, provided that there is a rule, provided that not less than 4/5 of the total number of members of such committees shall be elected by and from among the elected members of the panchayats at the district level and the municipalities in the district, in proportion to the ratio between population of the rural areas and of the urban areas in the district. So this is the rule. Not less than 4/5 of the total members have to be. So 4/5, minimum 4/5 of the total members of this committee has to be elected among the elected members of the panchayat at district level and municipalities at district level, with proportion to the population of rural and urban areas. Fine. Okay. Now the state legislature, so when the state legislature does the composition, the legislature has to keep in mind this thing, minimum 4/5. Okay. Now the state legislature also will make provision regarding functions relating to district planning, which may be assigned. The manner in which the chairperson of such committees shall be chosen, also state legislature will put. The chairperson of such committees, how they will be chosen. Fine. Next. Every district planning committee shall do this, all this work. Okay? This work will be done by the every district planning committee of the states. That is the draft. They'll prepare. They shall means it's mandatory. Okay, so they shall, while preparing the draft development plan, have regard to this matters of common interest between panchayats and municipalities, including special planning, sharing of water and other physical and natural resources, the integrated development of infrastructure, environmental conservation. They have to keep regard to all these things, and they also have to regard to the extent and type of available resources, whether financial or otherwise. They have regard to consult such institutions and organizations as the governor may by order specify. If the governor specifies by order, you have to consult these XYZ institutions or any kind of organizations, then the district planning committee have to do it. It's a constitutional provision. The chairperson of every district planning committee shall forward, mandatory, the developmental plan as recommended by the committee to the government of the state, not governor. Here the trick is it's not governor. So in question they can put to the governor. Usually things goes to the governor, but here the committee will decide something, it will recommend it, and the chairperson of that committee, district planning committee, will forward the development plan. It is mandatory to the government of the state, that is the minister, chief minister, or that government. the elected government and their council of ministers or the cabinet, anything you can say. So it is the correct word is government of the state, not governor. Next, 243 ZE. And this is district planning committee. Okay. Now we have a metropolitan planning committee. That is the committee for metropolitan planning. Same thing, exactly the same thing. There shall be constituted a metropolitan planning committee in every metropolitan area, and they will prepare the draft development plan for the metropolitan area as a whole. So here same thing the legislature of state will do regarding composition and the manner. And here provided that the rule is that not less than 2/3. Here there is no 4/5. So district DPC district planning committee के लिए it is 4/5. But metropolitan planning committee के लिए it is 2/3. 2/3 of the member of such committee shall be elected by and from the elected members of the municipalities and chairpersons of the panchayats in the metropolitan area in proportion to the ratio between the population of municipalities and panchayats in that area. Simple. So they has to be elected by and from the elected members of municipalities. Okay, so elected members of municipalities, chairpersons of the panchayats, where in that metropolitan area. So the proportion will be the according to the ratio between the population of the municipalities and panchayats in that area. Okay. And next is again the legislature of a state can also make provision respect to representation in such committees and the government of India and the government of the state and of such organizations and institutions as may be deemed necessary for carrying out the functions. So the state legislature also has a provision. They can make provisions regarding the representation in such committees of the government of India and the government of state and of such organizations and any institutions if it is required for carrying out the functions assigned to such committees. Also, the state legislatures can also make provisions regarding the functions relating to planning and coordination of metropolitan area. And finally, the manner in which the chairperson shall be chosen, it is also dependent on state legislature. There is no clear-cut procedure. The state legislature will do it regarding the manner in which the chairperson of such committees will be chosen. Same thing, every metropolitan area shall while doing the developmental plan, they have to do all these things. They have to take into account all these things. They have to give regard to the plans prepared by municipalities and panchayats in metropolitan area. If there is a matter of common interest between municipalities and panchayats, they have to take into account. They have to take into account the overall objectives and priorities set by the government of India and the government of state. So clear-cut government of India is also mentioned. They also have to take into account the extent and nature of investments likely to be made in the metropolitan area by agencies of government of India and government of state and any other available resources, whether financial or otherwise. They have to consult such institutions and organizations as the governor may order. If the governor orders, they have to consult it. Mandatory. Fine. So last is same thing, the chairperson of every metropolitan planning committee shall forward the developmental plan as recommended by such committee again to the government of the state, not governor. Government of the state. Fine. Continuance of existing laws and municipalities. This article is not required. Same like last panchayat. So we'll come to the last article, that is bar to interference by courts in electoral matters. So courts cannot interfere in electoral matters. So notwithstanding anything in this constitution, the validity of any law relating to the delimitation of constituencies or the allotment of seats to such constituencies made or purporting to be made under Article 243ZA shall not be called in question. Obviously, anything related to delimitation of constituencies shall not be called in question in any court. Next is no election to any municipality shall be called in question. Same provision we studied during the Panchayat class also. No election to any municipality shall be called in question, but except, like it means it can be called, but there has to be an election petition to the court. sorry, not to the court by the way, except by an election petition presented to such authority and in such manner as the state legislature will do. So it means question can be called regarding any election if there is a question coming whether the election was correct or not, anything. So an election petition has to be presented to whom? To any authority decided by the legislature. How? Decided by the legislature. Like authority and manner are decided by the legislature. Here also there is no High Court, Supreme Court or any kind of court is not mentioned. Okay? Fine. So next class we'll be doing cooperatives. Thank you.